Okay. Um, to my absolute horror, and I take full responsibility for this, I was looking at the course outline today, and it seems I somehow missed a week, which means we are now a week behind. And your first test, which is an online test, is scheduled for in 2 weeks' time, 22nd of October or 22nd of August. And I can unfortunately not change that then because we've got public holidays coming up, etc., etc. So we've got to stick to that date. The work that we're going to do today, specifically Unit 8, is quite complex. So I also don't want to rush. The week before the test is scheduled as a revision week, so we do have some time. But just to make sure that we do get through everything, I will also be offering an extra class on Saturday morning at 10 o'clock. For those of you that cannot attend, the class will be recorded. If you can make the time to attend, it's nice seeing your faces and being able to interact with you. I have started the whole process of uploading the recordings onto YouTube. I downloaded the recordings earlier today of the 2 classes that we've already had, and the one is already on YouTube. I sent you, yes, Mashumbe.
Ma'am, I just wanted to ask about the class for Saturday. Can you maybe move it to Sunday because we have 2 tests on Saturday?
We can absolutely to move it to Sunday. Is everybody just give me a thumbs up if that's okay with you? If Sunday will be a better idea. Anybody that agrees? Okay, so you're all agreeing. Fine. No, absolutely 100%. It makes no difference to me. And if you've got 2 tests on Saturday, then obviously you're not going to be able to attend a class. So we make it Sunday morning at 10 o'clock then. Sunday morning at 10. For those of you that go to church or whatever, please don't let me interfere with your religious practices. The class will be recorded. But for those of you that do or can attend, that will be appreciated. So yes, Mishumbe, 100%. We make it on Sunday then.
Thank you so much, ma'am.
Okay, so back to busy uploading. I uploaded the very first lectures already on YouTube. The other one I will upload this evening after class. My internet speed is just very slow at the moment, so it just takes forever to upload and download these recordings. But I will do that so that you have them. Let's share my screen. Thumbs up quickly if I've shared the screen, if you can see the screen. Okay, thank you, Irene. Okay, just remember, while I'm teaching, I do not have my Teams window open in front of me. I have the window with the PowerPoint open in front of me. So I will not notice if you are raising your hand. So please, if you want to, please feel free to interrupt if you have a question. You don't have to wait. You can interrupt me, but just switch your mic on and say something to attract my attention so that I know I need to stop and give you an opportunity to ask whatever you want to ask. So just to put you in the picture of what we did today, we started off in our very first lecture by explaining that the one thing that makes a company unique is the fact that there is a division between corporate functions, between ownership and management/management oversight. Next week, we look at directors, and then we'll learn more about the actual function of directors. Although I've been saying directors manage the company, that isn't strictly speaking true. You have employees, you have managers that manage the company. The directors just have an oversight function, but ideally they shouldn't get operationally involved, specifically not in a public company. But more about that next week. So I explained to you that you have this division between ownership on the one hand, and let's just continue using the word management on the other hand. And Unit 7 is a short unit. It's only 1.5 pages long, but it does address an important principle regarding this division of corporate functions. Namely, you've got the owners and you've got the board of directors. And the question arises, who is the boss? Who is the boss of whom? Interestingly, although we are looking at companies, specifically public companies, this whole concept of division of corporate functions also applies to state-owned enterprises. Maybe I must go to the lecture, go through the slides first, and then get back to the article that I read in the newspaper just this past week, which is actually very relevant. You people must read the newspaper. Okay, I know nobody reads newspapers anymore, but on your phones or whatever, keep up with the news, read business news. And every so often you will come across something which actually relates to what I'm teaching you. Just quickly give me a second. Okay, I'm back with you. I just wanted to check something. Okay, so division of corporate functions. The unit is titled Internal Relations. How do things work inside a company between these two organs? Remember to always, after you've gone through a unit, go back and check your learning objectives, check whether you have met these learning objectives. So in company law, there are a lot of people involved in a company. As I've already explained, you've got your shareholders, you've got your directors, you've got your management and your employees, etc., etc. But of all these people, you could refer to them as corporate functionaries. The most important two groups are referred to as the organs of the company. When an organ of a company acts as if the company itself is acting, they aren't merely agents of the company. They are the company. They are indispensable. Two organs is you've got your board of directors functioning as a board, not individual directors doing whatever. The board of directors functioning as a board. And then you have the members in general meeting. So that is the collective. These are not individual shareholders doing things on their own. Members in general meeting, the shareholders acting as a group, as a collective. I often use the example to explain the concept of organs of a company is that the board of directors and the members in general meeting can be compared to the brain and the heart of the company. A human being will not be alive if their brain doesn't work. Similarly, they will not be alive if their heart stops beating. In order for a human being to be alive, it needs a brain that works and a heart that works. A company cannot exist without a board of directors and shareholders in general meeting. The other people are functionaries. They are people that do a job. A human being can live a very, very productive life, even if they only have one arm. But they can't live without a brain and a heart. So those are like the organs of the company. And now the question arises is, these shareholders are the owners of the company. Do they have the power to instruct the directors about how they must do their job? How should they manage the company? Now, there's been lots of court cases about this, but and as time passed, I remember I've explained companies are very, very old. Over time, things changed. But since 1935, so practically the last 100 years, the prevailing legal thinking about this is contained in a court judgment, John Shaw versus Peter and John Shaw. You don't need to please remember that name. I'm not expecting of you to quote the court case. But the judge in the John Shaw matter said the following, using lots of big English words, namely that the general body of shareholders cannot themselves usurp the powers by which by the articles are vested in the directors, any more than the directors can usurp the powers vested by the articles in the general body of shareholders. What does that mean in ordinary English? In easy English, it means that both the shareholders and the board of directors have their own unique role in the company. And they cannot tell each other what to do. How do we know what the powers of the directors are? You will find the Companies Act states that a company must have directors who will manage the company. That is in the Companies Act. That is law. The articles of a particular company can address to what extent they can exercise these powers. But to answer the question, who's the boss? Nobody is the boss. Nobody is the boss of the other one. The ambit of their particular function is determined by the articles of the individual company. So who's the boss? You can really say, who's the boss? The articles. The articles is the boss. Both the directors and the shareholders are bound. They are both organs of the company with their original powers derived from the Constitution. And even a unanimous resolution, so unanimous 100%. So even if each and every one of the shareholders agrees, they still do not have the power to override the directors. You want to know which matters falls in the jurisdiction of each of these organs? You go back to the articles. The articles can, to a certain extent, restrict the powers of the directors by providing that for certain decisions, a resolution, a decision, or the approval of the shareholders is required. But it would also be silly okay, let's not go over that slide yet. It would also be silly for shareholders in the Constitution to try to retain too much control, so to speak. A provision in the article saying that for every single decision by the directors, they need the approval of the shareholders. That would just be vastly impractical. In Unit 8, we look at how the general meeting functions, and you'll see it's quite complex. So it would not make practical sense for the articles to try to unnecessarily restrict the powers of the board of directors. The company would not move forward. The directors need a measure of freedom. And if I could just interrupt myself here quickly, Albertina, you will remember in the very first class, when you spoke about Section 21 company, not Section 21, Section 60B companies, about all the shareholders also being directors. Just a quick reminder that what I'm teaching you now, I'm teaching from the point of view of public companies, where you have a large group of shareholders and only a small number of directors. As I already explained, and always remember this, try to understand this, that in a small private company, the line between shareholders and directors is often blurred. Very often, all the shareholders are also directors. What I'm saying now pertains to large public companies. So just bear that in mind. Each of these organs have their own original powers. The shareholders are in control to a certain extent, in the sense that if they're not happy with what the directors are doing, they always have the power to remove the directors. How that is done, we will look at in Sunday's class. So if the shareholders are unhappy, they can get rid of the directors. But at the same time, in terms of the Companies Act, the moment they fire the directors, they have to appoint new directors who will have the same independent powers. So, yes, they can fire them, but there will then be new directors who can also act independently. The crucial point here is the independence of the directors. As I've already mentioned, it would not be feasible to place too many restraints on the powers of the board. It would actually hamper the company. There are certain instances, very limited instances, 3 instances, where the general meeting may take over the function of the board, where they may intervene. Sorry. Firstly, if they're unable or unwilling to institute legal action on behalf of the company, that will usually be in a case when the directors themselves have done something wrong and the shareholders want action taken against the directors, but they're not going to, as a board, institute legal action against themselves as individuals. Then the company can do that. Companies Act has provisions for the steps to be taken. We don't look at those. If the board of directors is not functioning, for example, if there's a deadlock or there's no quorum, or if the act is voidable, if they have exceeded or abused their powers. But otherwise, except for those instances, shareholders can fire the directors, but they cannot dictate to them what to do. Any questions about that? Okay, let's move on to Unit 8. Unit 8 is entitled General Meetings. It addresses the manner in which shareholders conduct their affairs. Companies Act has got very precise and detailed rules about how the shareholders must make decisions. Let me stop there and rewind quickly. I wanted to tell you something about what I'd read in the newspaper just a couple of days ago. There was a report, a newspaper article. There was some meeting, some gathering of the people in charge, the big bosses of the state-owned enterprises. Now, remember, state-owned enterprises are, in fact, also companies. They come into existence by way of their own founding legislation, but they are still companies. And in a state-owned enterprise, you also have this division of corporate functions. You have the shareholder, which is the government, represented by the particular line minister, and then you have the board of directors. And at this meeting, in this article I read, Dr. Liaki Hangula was quoted. Dr. Liaki Hangula is currently the interim chairperson of the NUST Council. In the case of NUST, they don't have a board of directors, they have the council, but the council fulfills the role of a board of directors. And Dr. Hangula at this meeting made the statement, very carefully worded, that currently in our government we have a number of very young and very brilliant, those were his words, he described them as very young and very brilliant cabinet ministers, but they should remember that in terms of corporate function, as a minister, they cannot dictate to the board of directors of a state-owned enterprise how to manage, how to run that state-owned enterprise. I just thought that was a totally accurate statement that he made. Minister of Higher Education should not interfere with the NUS Council and start telling them how to do their job. Division of corporate functions. Questions? People must read the news. If you'd read that article, if you'd listened to this lecture and then read that article, you would have said, yes, we know that. That makes sense. That's what Ms. Hannekom taught us. So let's go on to Unit 8. Unit 8 is a long unit. It's a complex unit. It's got a lot of detail. Unit 8 does not require memorization. It concerns the manner in which the shareholders function in general meeting. But there's a lot of detail. So many people must vote for that. You need so many people to agree with that, blah, 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 blah. You do not need to memorize those details. In your face-to-face test and in the exam, I will be attaching an annexure to the test paper and to the exam, which is literally an extract from the Companies Act for you to use. Unit 8, not based on memorization, based on application. You need to know. I will give you the information, the numbers, the percentages. You need to know what to do with them. Let me share. Okay, so general meetings. Learning objectives, go through them. So firstly, we get two types of meetings. You get general meetings, which is attended by all shareholders. And then you get class meetings, which are called for a specific purpose for members of a specific class of shares. Go back, revise Unit 3, the capital of a company, where we looked at the different types of shares and the different classes of shares. Concept of classes of shares, class rights. When are class rights changed? Very relevant for the application of Unit 8. So every company must have at least one meeting every year, namely the annual general meeting. You are welcome, if you're writing a face-to-face test, to use the abbreviation AGM. The company must have an AGM once a year, every single company. The minutes of the AGM must also be lodged with the registrar of companies. So he's going to pick up if a company hasn't been having these annual general meetings. The annual general meeting is the one opportunity for the directors, the board of directors, to give feedback to the shareholders, to inform the shareholders of what is happening to their property, to their company. You come from an accounting background, your annual financial statements are lodged or submitted at the annual general meeting. so that shareholders can be informed of the financial state of the company. Now, the question is, when must a company hold its annual general meeting? The very first meeting, there's two answers to that question. It depends whether it's a first meeting or a second, third, fourth, or fifth, a subsequent meeting. The first meeting must be held within 18 months after the company's incorporation registration. Incorporation registration synonyms, remember that. So within 18 months, at least 18 months, after the company has been registered, it must call its first annual general meeting. Any meeting after that, and if I ask you a question about this, I will state clearly in the question whether this is the company's first meeting or whether it's the second or third or whatever meeting. In order to determine when the next meeting must be held, after the first one or after the second one or whatever, there are two requirements. If I ask you when must the company hold its second annual general meeting, you have to, and you'll be getting, remember, you don't need to memorize this 9 months, 15 months, whatever. It's in the handout that I give you. You need to know how to calculate. There's two calculations that you have to make. The Act says the company must hold its annual general meeting or a subsequent annual general meeting no later than 9 months after the end of each financial year. I will tell you when the company's financial year ends, or if I didn't state it, you can work as the general principle is for the majority of companies. The financial year ends the last day of February every year. So no later than 9 months after the end of each financial year. So if the company had an annual general meeting in, say, September 2025, the next financial year end after that meeting will then accordingly be February 2026. So no later than 9 months after the end of each financial year. So 9 months after the end of February 2026, you literally count on your fingers. February, March, April, May, June, July, August, September, October, November. So you get November 2026. But then there's another requirement. Still within 15 months of the date of the previous annual general meeting. And I will give you that date if it's necessary. So you take that date. From that date, you count 15 months. And then you've got 2 dates, and then you take the earliest of these 2 dates. At the bottom of page 38, there is an example of how to calculate this. You can't just take the 9 months. You can't just take the 15 months. You need to take both and calculate them both, and then take the earlier of these 2 dates. I mentioned that the Act is primarily written for public companies. I told you that a company must have a meeting every year. It must have an annual general meeting. There's an exception to this. Company does not have to hold an annual general meeting, provided that all members entitled to attend the meeting agree thereto in writing. Albertina, this is your question, or what you understood. If all your shareholders are also directors, the directors don't have to report to the shareholders because the shareholders are directors. They know what's going on in the company. The Act doesn't say the majority of
Yes,
members.
ma'am, I see now.
Sorry, I missed that. Somebody spoke?
No, I was saying, yes, I'm now getting it.
Okay, yeah, thank you. You're my friend. Sorry, you're my superhero in this class. So forgive me if I'm constantly using your name. Because it's very clear that you understand the work and your questions are such good questions, so insightful questions. So forgive me if I'm constantly, if I'm embarrassing you, please feel free to tell me, ma'am, stop referring to me. Leave me out of this. I don't mind. I don't want to put you on a spot. So the annual general meeting Act doesn't say if the majority of the members agree. It says if all the members agree. Obviously, if you have a company with 200 shareholders, it is unlikely that every single one of them will agree in writing that we don't have to have an annual general meeting. If you've got a small company, 5 shareholders, they all know what's going on. They can agree in writing not to have an annual general meeting. When the annual general meeting is called, it requires 21 clear days notice. And you need to understand the concept of clear days. Okay, I'm going to get back to that. Clear days. How do you calculate clear days? You start on the day, counting on the day after the notice was given. And you do not include the day of the meeting. Saturdays and Sundays are included, but public holidays not. We'll get back to notice periods again, then I'll repeat this again. So clear days, not the day the notice is given, not the day of the meeting. So in between that, you include your Saturdays and Sundays. You do not include public holidays. If I'm required to, or if I'm asking you to calculate, was the notice period correct, or when can the meeting be held, I will tell you, I'm testing your ability to count 15 days, 21 days or whatever, not testing your ability to know when each and every public holiday in Namibia is. So if there is a public holiday in that period that you must know, or I want you to remember, okay, we shouldn't count that day, I will give you that information. Okay, just we can go through this quite quickly. I didn't realize I had these slides. When must the first meeting be held? If the company is registered on the 1st of September, within 18 months, so from the 1st of September, 18 months after that is February 2027. Always remember to give me the year. You can't just say end of February. I need to know February 2027. Subsequent meetings no longer than 9 months after the end of each financial year, but still within 15 months. I did give you an example of this. I will also share the slides. So just go through the slide on your own, which illustrates how you apply these provisions. You don't need to remember 18 months, 9 months, 15 months. You will have that in your handout. Okay, sorry. Okay, so that is annual general meetings. The rest of the unit, we focus on meetings in general, just to make sure that you understand the terminology used. When we did the previous unit, I said I used the term shareholders in general meetings. So I'm not referring to individuals acting. I'm actually referring to them as a collective. How does this collective act? Shareholders make decisions by way of valid resolutions adopted at valid meetings. If the resolution was not validly adopted, the decision is not binding. Cannot adopt a valid resolution at a meeting which was invalid. In order for meetings or shareholders' resolutions to be valid, the meeting itself must be valid. There are 3 requirements for a meeting to be valid. In the first instance, it must be properly convened. Then it must be duly constituted, and it must be properly conducted. In that sequence. And if I'm asking you questions about shareholders' general meetings, the sequence is important. The format is important. You don't first address the voting and then tell me, oh, but it wasn't properly convened. It's convened first. That's sending out the notice, getting the people there. Must be called by persons authorized to do this, allowed to call meetings. Notice must be given at correctly, the correct time, the correct information, and it must be sent out to all the people entitled to attend. So you first convene the meeting, then duly constituted. That's the day of the meeting. You send out the notice. You don't have the meeting and then you remember, oh, I must send out a notice. Sequence matters. Must be duly constituted. Correct person must chair the meeting. There must be a quorum. I'm going to explain all of this in more detail. And then at the meeting itself, it must be properly conducted. Voting must take place in the correct manner. And the prescribed majority must vote in favor of the resolution. My students battle with this in the sense that if they answer questions in this regard, they muddle everything up. They just write the first thing they can think of, they write it down. Instead of sticking to this precise sequence, you will lose marks if you don't stick to the sequence. I don't know why you struggle with this. You are accountants. A balance sheet has a specific format. And if you prepare a balance sheet, you follow the format. You don't just chuck everything in haphazardly. So I don't know why you can't also keep the sequence the way it should be. Remember that, it is important. So the meeting must be properly convened. Issues that we look at to check if the meeting was properly convened. We look at who is permitted to give a notice of a meeting. The notice period. Was the meeting given long enough in advance? And how must it be given? And what information must it contain? So who may give notice? Firstly, meetings are generally called by the board of directors, acting as a collective, acting as the board, not acting as a random individual director, but acting as a collective. The whole board, not the managing director on his own. The managing director representing the board. On his own, randomly, he doesn't have the power to call shareholders' meetings. Then it could happen that a member or members want to feel there is a need for a meeting and the directors are not calling this meeting. The Act empowers shareholders to call meetings in terms of Section 188 and Section 189. We will look at those in more detail in the next slide. In addition, who may give notice? The Registrar of Companies and the court may call meetings. That doesn't happen all that often. So, if a member wants to call a meeting, they can use either Section 188 or Section 189. All these sections, Section 188 and Section 189, are included in your handout. You don't need to remember these details. I can give you a case study and tell you that whoever, Susanna, Ryan, Christine, and Bertha are the shareholders. And I'll tell you how many shares they each have. I'll give you all the detail you need. There is also, by the way, if I can interrupt myself, on e-learning, there is a sample question based on Unit 8 with a model answer. Make sure in your preparation you look at the sample question so that you can see what type of thing I'm expecting. So Susanna, Ryan, Christine, and Bertha are the shareholders. I've told you how many shares they each have or what percentage shares they each have. And I'm asking you, can Ryan call a meeting in terms of Section 188? And then you need to go and look in your handout, what are the requirements for Section 188? And check, does Ryan meet these requirements, yes or no? If he meets them, he can call a meeting. If he doesn't meet them, he cannot call a meeting. Be careful, read your questions carefully. Sometimes I say, can Ryan call a meeting in Section 188? And you're writing your test and you look at the requirements for Section 189. And then you get it all wrong because you haven't read properly, because you weren't focusing. So make sure you follow the correct requirements for a particular, whatever the question refers to. So let's look at these two sections. I can also ask you, I have asked this before, to compare, or what is the difference between Section 188 and 189? There I have it in a nice table for you, setting out the differences. Section 188 requires 2 or more members. So if I've asked you, can Ryan call a meeting in terms of Section 188? You don't even have to look at his individual shareholding. You can already say, no, he cannot, because he is just one person. He will have to be joined by Christine or Berta or whatever. Section 188 requires 2 or more shareholders acting together, who together, not individually, together hold at least 10% of the issued share capital of the company. I will give you the shareholding of the individual persons that I'm referring to in the case study. I will also give you the information about the issued share capital, and you need to calculate then these two people, their total shareholding combined. Is this 10% of the issued share capital? Yes or no? If it is, they can call a meeting. If it isn't, they can't call a meeting. Remember, it's not 10% each, it's a combined shareholding of 10%. Section 188 in the Companies Act states that, save insofar as is otherwise provided in the articles of the company. Translating that into simple English, it means that the provisions of Section 188 can be changed in the articles of a company. So the articles can provide that 3 or more members that have at least 20%, blah, 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 blah. Whatever, if it is changed in the articles, then whatever is stated in the articles will be applicable. But I will give you that information. Normally I don't say that it has been changed, so you provide, you use the provisions as stated in the Act in your handout. Section 189 is not subject to the provisions of the articles, which means it cannot be changed. Any attempt by the company to change Section 189 will be invalid. Company can change Section 188 and try to make it almost impossible for shareholders to call a meeting. Say 100 members with at least 90% of the share capital, blah, 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 blah. If Section 188 isn't workable, they will always have the right to fall back on Section 189, which cannot be changed. Section 189 requires at least 1 member. So whereas Ryan will not be able to act in terms of Section 188 on his own, he will be able to act in terms of Section 189 on his own. Requires at least 1 member that holds at least 5% of the capital that carries voting rights. The Act itself, so in the handout, the terminology used in the Act says at least 1 member who holds at least 1/20th of the capital that carries voting rights. And to my absolute horror, coming from accounting students, I sometimes get students telling me that they must have at least 20%. 1/20th isn't 20%. Quantitative methods, you should know this. 1/20th is 5%. So at least 1 member that holds at least 5% of the capital that carries voting rights. your red flags should be starting to, or red lights should be starting to go on here where I'm saying capital that carries voting rights. Go back to Unit 3 about voting rights. Remember, your preference shareholders generally do not have voting rights. So capital that carries voting rights in general refers to your ordinary shareholders, subject to certain exceptions. Issued share capital includes all your shareholders, preference and ordinary shares. Then notice must be given. Okay, sorry, I skipped a slide. Notice periods. If I can just go back there, the meeting to be properly convened. Who may give notice? Either the board of directors or shareholders, provided they meet the requirements of either Section 188 or Section 189. Then the correct notice period must be given. Notice periods. Annual general meeting, we've already seen, must be 21 days. Other general meetings, ordinary general meetings, 14 days. If the business of the meeting is to vote and adopt a special resolution, the requirement is 21 clear days. And then we get something called special notice. Special notice is 28 days. Don't confuse a special resolution with special notice. Special notice refers to the notice period, 28 days. Special notice is required only in 2 instances, namely for the removal of directors and the removal of the external auditors. What are clear days? Does not include the day the notice was sent or the day of the meeting. It includes Saturdays and Sundays, but it excludes public holidays. Clear days, just a repetition there. So if the invitation, if the business of the meeting is to adopt a special resolution, you need 21 clear days. If the meeting is sent on the 1st of September, you don't count the 1st, then you count 21. So count on your fingers, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Now I've lost count here. No, that's 20. 22, so 20, if you count 21 days after the 1st, you get to the 23rd of the meeting, but you don't count that day. That can only be held the next day. So the earliest date for the meeting will be 23 September. In practice, it hardly ever happens that a company gives the notice on such exact days. It will not happen in practice that they send out an invitation on the 1st calling a meeting for the 23rd, because there's always a risk that delivery of the meeting could be delayed or something, and then no proper notice was given. And the meeting ends up not being valid, because the meeting cannot be valid if it is not properly convened. On page 41, in the middle bottom last paragraph, page 41, discusses the whole issue of notice periods that I've just explained. In the middle there's a paragraph that refers to short notice. I don't actually have a slide on short notice, but there is a provision that if the notice was not sent out in time, short notice the meeting can proceed if agreed before at the meeting by the majority in number of the members having the right to attend to vote and who hold at least 95% of the total voting rights of the members. So if notice wasn't given long enough, I'm going to quickly put it in here. So that if I send you the slides, you have the short notice can be condoned if 95% of members, having the condoned if approved by having the right to vote. So 90%, 95% in number, counting the heads, who hold at least, I'm wrong here, approved by the majority of the members. So the majority in number, count the heads, just more than 50%, but that 50% must who hold at least 95% voting rights. That's in the company, that's not just at the meeting. So if I've give you a case study and I've told you that all the shareholders are present, but they will short notice, then you can assume that they will condone the short notice. They meet the requirement. All of them is the majority and they hold at least 95%. It's just for the sake of completeness here, with voting rights. Okay, now that slide is more complete I will share the slides with you after the class. So now we've met the first requirement. Any questions about the first requirement? The meeting must be properly convened. Everybody's still with me? I know.
Yes, ma'am.
Yes, Albertina, are you with us? Okay, great. I know this is a lot of information, a lot of detail that I'm throwing at you now. That week before your online test, when we have the revision class, I will also do some practical exercises with you. Not practical exercises, some case studies, some possible questions regarding the application of all these details. So our meeting is now properly convened. Our meeting is properly convened. Now the day of the meeting arrives. And before the meeting can proceed, and before you can say, okay, this is a valid meeting, remember, valid resolutions can only be adopted at valid meetings. The meeting must be duly constituted. It's been properly convened. Now we look at duly constituted. Duly constituted, the proper person must be appointed or must act as chairperson. Who acts as chairperson? That's normally provided for in the articles of the company. There can be differing rules whether the meeting selects a chairperson at the start of the meeting or whether it's automatically the chairperson of the board or whatever is provided in the articles must be followed. Then there must be a quorum. And then we also need to look at the concept of proxies. What are proxies? What is a quorum? Term quorum doesn't only apply to company meetings. The term quorum applies to meetings in general. A quorum is the requirement that is the minimum number of members that must be present at the start of the meeting in order for the meeting to validly proceed. If not enough people have pitched up to attend this meeting, the meeting cannot validly go ahead. What does the Companies Act say about quorums? For a public company, the requirement is a minimum of 3 members with voting rights that must be personally present. So if only 2 people have pitched up, then the meeting cannot proceed. There is no quorum. For a private company, the requirement is 2 members that are entitled to vote must be present in person or by proxy. Public company, they must physically be there, personally present. Private company, you include your proxies. For a special resolution, section 207, there are different quorum, specific quorum requirements that we will look at the end of the slideshow. So what is a proxy? A proxy is simply the term, and once again, the word proxy is a general English word. It's not unique to companies. What is a proxy? A proxy is a person who has been given the authority to represent another shareholder of the company and vote on their behalf. Now, the Companies Act states that, any member of a company may appoint a proxy who does not have to be a member to attend, speak, and vote on their behalf at meetings of the company. Companies Act says any member may appoint a proxy who does not have to be a member. Do not interpret that as who may not be a member. I've had this before, that's why I'm warning you. So our shareholders were Susanna, Ryan, Christine, and Bertha. And I'm giving you a case study based on a meeting of general shareholders. And I tell you that Ryan gave a proxy to Susanna. And I get answers saying, but Brian can't give a proxy to Susanna because Susanna is also a shareholder. No, that isn't how it works. It doesn't have to be a shareholder. Ryan is welcome to give a proxy to Asser. In practice, that never happens. You normally give, it is the normal practice to give your proxy to another shareholder. Asser doesn't want to go and attend this meeting of a company that he's got nothing to do with. It's a waste of his time. He'd much rather stay at home and watch TikToks. But Susanna was going in any event. Seeing that she is going in any event, Ryan is going to give her a proxy because he's got other business to do, but he still wants his vote to count. So a proxy, simply appointing a representative to vote on, to speak and vote on your behalf. Whether your proxies can vote or not will depend on the type of resolution. I'm going to elaborate on that. So now your meeting, sorry, that's not the slide, that's the slide I wanted. It's been properly convened and it is duly constituted. There is a quorum. Now the meeting proceeds and voting can take place to adopt this resolution or not.
Can I have a question?
Yes, Susanna, you were saying something?
Yes, I just want men to clarify. So does the proxy need to be a member of the company, or they do not need to be a member of the company for them to be appointed as a proxy?
It doesn't have to be. The Companies Act says a person may appoint a proxy who doesn't have to be a member of the company. But in practical terms, it normally is. So if you're a shareholder, you can appoint Ilse, who isn't a shareholder. But Ilse doesn't want to go and attend this meeting. She'd rather stay at home and study company law. So you're going to rather give your proxy to another shareholder, to Ryan, to Christine, who are attending the meeting in any event, rather than send a total stranger. But you may, by law, you may. It doesn't matter whether it is a shareholder or it isn't a shareholder. Are you clear?
Yes, ma'am. Thank you.
Okay, so now voting takes place. In order for the resolution to be valid, it must be adopted in the correct manner. The voting must take place in the correct manner, and enough people, the prescribed majority, must vote in favor of the resolution. In order to be able to see, have enough people voted for the resolution, you need to understand the concept of voting rights. The basic principle in the Companies Act is that every member of a company may vote. There are exceptions to that. But the basic principle is every member, every shareholder may vote. If it's a company with a share capital, and most of my questions are based on companies with a share capital, the underlying principle is that every member has a vote in respect of each share held. Not every member has one vote, but every member has a vote in respect of each share held. So your majority shareholders will have more votes than your minority shareholders. In a company limited by guarantee, obviously there are no shares. There you simply count the people. Every shareholder has one vote. Distinguishing then between par value shares and no par value shares. Let's do the easiest one first. For no par value shares, every shareholder has one vote for each share held. So if whoever, Ryan holds 20 no par value shares, Ryan has 20 votes. Par value shares, your voting right is determined by the nominal value of your shares. Companies Act states that the total votes of a member must bear the same proportion to the total votes in the company as the nominal value of his or her shares bears to the nominal value of all shares issued by the company. Going to give you an example of how, or explanation of that in a moment. Let's go through that again. Total votes of a member must bear the same proportion to the total votes in the company as the nominal value of his or her shares bears to the nominal value of all shares issued by the company. That might sound confusing. It actually isn't. Before I explain this, let's go back to Unit 3. I said, in general, every member of a company has the right to vote. You learned in Unit 3 that preference shares do not have a general voting right, except in two circumstances. If their dividend has remained unpaid, or if the resolution that is proposed directly affects their rights. In a case study, I will give you the necessary information about whether their dividends are fully paid to date or whether their dividends are in arrears. I will also give you information of what the content of the resolution is. You need to decide for yourself whether this resolution affects the rights of the preference shareholders. Go back to the section, the paragraph in Unit 3, where I discussed the variation of class rights. Class rights are only changed if the resolution...
Sorry,
yes.
I think, is it not Unit 5?
Am I saying Unit 3 the whole time?
Yes.
It's Unit 5. I'm so sorry. Please, everywhere where I said Unit 3, right, wipe that out. It's Unit 5.
All right.
What is Unit 3 about? What was Unit 3 about? I can't
Types
even
of
remember
companies.
now. Types of companies. Oh, my goodness. Sorry. All my references to Unit 3 in this lecture that I've been given refers to Unit 5, capital of a company. I actually have it next to me. I have this unit next to me at the moment. I can quickly get the reference for you. That's on page 25 of the notes. Unit 5, paragraph 4. deals with a
Yes.
variation of class rights. So
Yes.
if class rights are varied, if they, after the resolution, they will differ in substance, but a mere change in the value of the shares isn't a variation of your class rights, because the value of your shares isn't a right. Question that you can ask in your head to decide, am I going to include the preference shareholders or not? Look at the content of the resolution. Does it affect the whole company, or does it affect only the preference shareholders? If it affects only the preference shareholders, it will be a variation of their class rights. If it affects the whole company, it doesn't affect the class rights of specifically the preference shareholders. So that's a quick rule of thumb, because you have to decide in your case study, are you going to be including them or not? So voting rights. And to read that for you again, the total votes of a member must bear the same proportion to the total votes in the company as the nominal value of his or her shares bears to the nominal value of all shares issued by the company. So the first thing you need to do is calculate what is the nominal value of the issued share capital. I'll give you sufficient information to be able to calculate that. Issued share, in the example, if the issued share capital of the company consists of 400 Class A shares with a par value of $2 each, you do the maths, you're accountants. Do quick sum, 400 Class A shares, $2 each, that gives you total nominal value of the issued share capital is $800. Easy maths. And I won't give you my purpose between assessing this unit is to see whether you can apply these concepts. It is not to test your ability to do maths. So I won't give you mega complicated. It will literally be things like 400 shares worth $2 each. Easy maths, but you are permitted to bring a calculator and use a calculator, because I have shockingly discovered that even my accounting students these days cannot do mental maths. Quick question before I carry on. Want to test you quickly. What is a quarter of 4? Hands up, quick. What is a quarter of 4? Yes, Nathan.
It's 1, ma'am.
Thank you, Nathan. You have just restored my faith in my students. Thank you. I have literally stood in front of a face-to-face class when I still taught full-time students face-to-face, asked them what is a quarter of 4, and had them grabbing for their phones to get their calculators because they don't know what a quarter of 4 is. And they don't calculate a quarter by dividing by 4. They calculate a quarter by timesing by 0.25. But thank you, Nathan. You have restored my belief in this and my confidence in this class. I will not expect overly difficult calculations from you. I try to keep them because it's not about the maths. It's about the principles. Start off by calculating the total nominal value of the issued share capital. Then the individual shareholders, in order to see what are the voting rights of the individual shareholders, You calculate for each year. I've only used one. Normally I have a number of different shareholders, but I give you sufficient information. Mbiri, in my example, owns 100 Class A shares. So what is the total value of Mbiri's shareholding? You do the maths. 100 times 2 gives you 200. Your provision says the total votes of a member must bear the same proportion to the total votes in the company as the nominal value of his shares bears to the nominal value of all shares issued. So what percentage of the total issued share capital does Mbiri own? Simple calculation there. So somebody has, please keep your mics muted unless you're specifically talking to me. Otherwise, there's just background noise. So you calculate what is the percentage of Mbiri's shares. He's got 200 of a total of 800. Calculate the percentage, 25%. What are Mbiri's voting rights? 25%. He holds 25% of the votes in the company. So that sentence might have sounded very complicated. Once I've illustrated it to you like this, it isn't actually that complex. Now, how does voting take place? Voting can take place in one of two ways. Either by hand or by poll. Voting by hand, literally, you stick your hand up into the air and the scrutineer is the term used for people that count votes. They count 1, 2, 3, 4, 5. If voting takes place by hand, proxies are generally not included. Simple, because it's one person, one vote. So you stick one hand up into the air. If you're holding a proxy for somebody else, you don't stick two hands up into the air. The Act provides for a different procedure when it comes to special resolutions. We get to that at the end of the slideshow. All voting can take place by way of poll. Your vote is your secret. You vote on a piece of paper. If you vote by poll, your voting is counted in accordance to your voting rights. So in our previous example, Mbiri has got 25% of the voting rights in the company. He can cast 25%. His vote will be worth 25%. Voting by hand, shareholding, value of your shareholding is irrelevant. Even if the majority shareholder and the minority shareholder, one person, one vote. Voting by poll takes place in accordance to voting rights. Demand for a poll. Companies Act provides that if voting took place by show of hands and the shareholders are not happy with the outcome of the voting, that they will always have the right to demand a poll. In order to demand a poll, requirements that have to be met, at least 5 members with voting rights at the meeting must together demand a poll. Or, so these are alternative provisions, so you only need to meet one of them. Either 5 people or a member or members with at least 10% of the voting rights in the company, of all members having to vote at the meeting, or a member or members entitled to vote at the meeting holding at least 10% of the issued share capital of the company. So either 10% of the voting rights or 10% of the issued share capital, or 5 people in person, irrespective of the value of their voting rights. Calculating this, proxies are taken into consideration as if the proxy giver was personally present. So for the purpose of your calculations, you count their voting rights or count them as a person as if they were physically present. Be careful here. Students seem to misunderstand the term demand for a poll. Sometimes I give you a scenario and I tell you that voting took place by show of hands. And then I ask you, sorry. Oh, bless me. I'll tell you, voting took place by show of hands and so many people voted in favor, blah, blah, blah. And then I ask you, tell you about so-and-so shareholders unhappy. May they, or will it make a difference if a poll was demanded? Then I'm not asking you, may they demand a poll? Then I'm asking you to calculate what would the outcome have been if you took voting rights into consideration. If voting took place by poll, there's no need to demand for a poll. If I've given you something, you don't have to demand it. So just understand the concept of when demand for a poll, when will that be used? That is if they want to insist, okay, we want to vote. What are the majorities that are required? You get 2 types of resolutions. You get ordinary resolutions and you get special resolutions. An ordinary resolution is adopted by a simple majority. A simple majority is 50% plus 1. Not 51%, 50% plus 1, just more than half. For a special resolution, you require a special majority, which is 75% of the shareholders present and voting. We're going to get back to that in the next slide. When you count the vote and calculate whether the particular resolution has been adopted or not, very important, you work with the shareholders present at the meeting, not all the shareholders in the company, only those that bothered to pitch and or alternatively give a proxy to somebody. If you didn't bother to pitch up at the meeting and you didn't bother to give anybody a proxy, you don't have a vote. Questions about this before I carry on with special resolutions? No questions? So special resolutions. This is section 207. Section 207 of the Companies Act. The requirements for a validly adopted special resolution are as follows. Notice required is at least 21 days, 21 clear days before the meeting. Notice must be in writing and it must state the terms and effects of and the reasons for the resolution. Notice must state the intention to propose a special resolution, the terms and effects of the resolution, and the reasons. So there must be sufficient information in this written notice for you to start deciding whether you want to vote yes or no. In order for the meeting to be properly constituted, there must be a quorum which must consist of at least 1/4, 25%, 1/4 of the total votes of all members entitled to vote at the meeting must be present in person or by proxy. 1/4 of total votes of all members entitled to vote at the meeting. So you need to make your decision here. Are you going to include your preference shareholders? Do they have the right to vote at the meeting or not? 1/4 of the total voting rights. Work with total votes here, not number of members. 1/4 of the total voting rights entitled to vote at the meeting must be present in person or by proxy. Then when you vote, voting can take place either by a show of hands or by poll. Voting by show of hands is expressly permitted for special resolutions in terms of Section 207. The requirement, the majority required, is the same whether voting is by show of hands or whether voting is by poll. 75%, at least 75% entitled to vote who are present. Present in proxy or by person. So in order to calculate the quorum, in order to see whether there's a quorum, you look at the voting rights in the entire meeting. In the entire company, all the voting rights in the company. When it comes to voting, you only work with those that are physically or by proxy at the meeting. Those that didn't bother to attend, you ignore them. 75% show of hands, one person, one vote. Voting by poll, 75% of the total votes, total voting rights. Let's change this. So an important reminder here that if you're dealing with a special resolution, your proxies are always taken into consideration. That's it. That is the whole of Unit 8. That was a lot of information. It's only 7 o'clock now. The class is supposed to continue till 8, but I don't want to start with directors now. We'd rather have a class then on Sunday morning as suggested. I think I need to stop now so that this can all sink in. Otherwise, you're going to end up being overwhelmed. Any questions? Okay, if there's no questions, thank you so much. Let me stop sharing. Thank you so much for attending. Sunday morning then at 10 o'clock for an extra class. It will be recorded. Thank you so much. Bye.
Bye, ma'am.